Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On November 14th, 2024, the defense filed a number of motions to suppress evidence, seeking an order to throw out the specific evidence that was the subject of the particular motion. The one that we're going to go over now is the motion to suppress a memorandum in support regarding a search warrant for Mr. Kohberger's person. Page 1 tells us that this is specifically resulting from the search of Mr. Kohberger's person in the Latah County Jail. Latah County Jail is where Mr. Kohberger was returned to following his arrest and his detainment in the Monroe County Jail from December 30th, 2022, the date of his arrest, until he was returned to Idaho a week later and went directly to the Latah County Jail where this search occurred. He is challenging the search as being illegal, as offensive to the Fourth Amendment of the United States Constitution, which bars illegal searches and seizure. And if we go to Mr. Kohberger's argument section, beginning on page 3, you will see that the Fourth Amendment at the bottom states unambiguously that, quote, no warrants shall issue but upon probable cause supported by oath of affirmation, and particularly describing the place to be searched and the person or things to be seized, end quote, citing to Groh versus Ramirez, which is a 2004 United States Supreme Court case. Now, why would defense counsel, and we see here that it's Jay Logston and Ann Taylor who have both signed this on the last page of this document, why would they be citing to a United States Supreme Court case? Why not an Idaho Supreme Court case, as they do many times in their filings? Well, it's because the Fourth Amendment is to the United States Constitution. It is not to the Idaho Constitution. It's to the federal Constitution. The federal Constitution is the supreme law of the land. We know that by looking at the Supremacy Clause, meaning that any laws of any state or local government that conflict with or would be deemed violative of anything that's in the United States Constitution would be struck down as unconstitutional. And the final authority over what the Constitution says or doesn't say is the United States Supreme Court. So that's why you'll see very frequently when the Constitution is cited, whether it's the Due Process Clause, whether it's the Sixth Amendment, whether it's, as here, the Fourth Amendment, you'll see a lot of cases, typically both sides, will cite to the United States Supreme Court, and that's why. So Mr. Kohberger is making the argument that this search was violative of the Fourth Amendment, which protects people from unlawful searches and seizures of 4 things: the person, the human being, in other words, their homes, their papers, or their effects. So this is now looking at this first category, is the challenge that Judge Hippler will have, because the state of Idaho has vehemently denied any Fourth Amendment violation in any of the motions to suppress, including this one. The defense attempts to persuade Judge Hippler that this was an unlawful search and seizure based on an affidavit which was, they assert, too general, when the Constitution and cases by the Supreme Court interpreting the Constitution, generally this must be a specific search. So they are alleging, in conclusion, that Mr. Kohberger requests that the court suppress all evidence obtained by police via the warrant that permitted them to search his person. These matters are now up for hearing before Judge Steven Hippler on the 23rd and 24th of January. Unfortunately, we don't have access to the witnesses and the exhibits that Mr. Kohberger has brought forth in trying to persuade the court to grant this motion, because the exhibits and the witnesses that he intends to call are all under seal. This will now conclude this episode of the Indie Zone. Thank you for joining us here today.